Hello, and thank you for logging in to watch this webinar on office leases. And I think one of the most difficult things with dealing with clients on office leases is that the clients think that it is just a bit of paperwork and it's all standard. After all, I renewed my car insurance yesterday and I didn't bother reading the policy to see if it was the same one as the one before. And I certainly haven't read my terms of reference for any of the internet sites or anything like that. So everyone just assumes that there is somebody out there holding their hand and making sure it's all okay, and that if anything goes wrong or is nasty or horrible, there will be something in legislation, government, or something which will stop the landlord being nasty. And so they think that they've got the same sort of consumer rights as if they bought something from John Lewis or Marks and Spencer's, and that the property has to be suitable. So at the end of the lease and during the lease, you will always get dispute over whose was what and whose responsibility. So it will be things like walls, interior, doors, door frames, windows, glass, carpets, floor coverings, ceilings, shop fronts, window blinds, dividing walls, roof spaces, foundations, light fittings, heating, venting, and air conditioning, floor screeds, plaster, and that sort of thing. So if you look on my notes, you will see the premises definition there. And you can see the MCL1 has lots of things like windows, window frames, window blinds, excluding decorative finishes in the case of a high-rise building, because obviously the tenant's not going to be able to get out there to paint them, doors and door frames, plaster and internal surfacing, one half severed vertically of non-structural walls, such as partition walls. If it's a wide use, the rent will be higher. If it's a narrow use, then the rent will be lower on rent review, but it might be more difficult to find an assignment. So think about your permitted development rights, think about the client's proposed use, think about the effect on rent, and also think about qualifying the landlord's ability to object to uses by the usual provision not to be unreasonably withheld or refused. The next thing, which is quite a hot topic at the moment, is the green lease clauses and the Mies mess. And as you know, from the 1st of April 2023, landlords cannot rent out property of an F or a G. So the property may be an E at the moment, but the landlord is terrified that the tenant might do something to mean that the EPC is no longer an E and it's now an F or a G, then goes bust or hands it back at the end of the lease, and the tenant then runs away and the landlord's stuck with a property that they can't rent out.